Rumley. I'm the other staff attorney from the National Ag. What I'm going to be covering today is more of the leasing aspects for leasing out property for hunting and recreational purposes. Basically, all a lease is, it's a form of contract. And contracts are one of these things we deal with every day, whether we know it or not. Everyone here signed a contract or entered into a contract today when you walked through the door and paid your money for the food. That was the reason why you paid the money. You paid money, in return you received food. Every time you stop at a fast food restaurant, every time you stay the night at a hotel, you're entering into an agreement. For the services rendered, you'll be providing some form of payment. A lease is just one of the many types of contracts out there. All of them have certain things in common, but there are some unique aspects that you find when you're dealing with leases that you need to be thinking about on the front end. As I said, a lease is basically just another form of a contract. Every contract out there has certain elements. And just like when Beth was talking about concepts of negligence, if you're missing one of these aspects, you don't have a contract. For contracts, you have to have some kind of subject matter. You got to know, what are you talking about when you're entering into this agreement? If neither party can agree on what they're trying to enter into, there's no meeting of the minds, there's no contract. There has to be some kind of offer to enter into a contract. That offer's got to be accepted. There has to be consideration paid. There has to be some kind of something changing hands. If I make an offer to you and say, hey, would you like $1 million? I've made an offer. Is there subject matter? Absolutely, $1 million. Are you going to accept it? I should hope you would accept it. Is there a contract? In that case, there wouldn't be. There's no consideration. What are you giving me for that $1 million? If I offer to give you something for nothing in return, what have I done? I've offered to make a gift. I'm not entering into a contract with you. The final part of it is you have to have capacity to enter into the contract. There's two different types of capacity. One's the mental capacity. You can't be too crazy. A little bit crazy is fine. Now, what constitutes too crazy? I mean, that gets into a decision made by the courts. But the thing that's more important when you're talking about capacity is they need to be 18 years of age, especially when you're dealing with hunting leases. People under the age of 18, they can enter into a contract, but they can also get out of a contract later on. They can breach the contract themselves. Now, if it's buying a necessity like food or clothing and stuff like that, there are ways to bind them into this contract even though they're under 18. When you're dealing with things like a recreational use or a recreational lease, it's a great thing to have, but it's not a necessity. So they can back out of this. So be careful entering into leases or contracts with those under age or those that are under age 18, unless you've got a parent or guardian that's also signing with them. And as I said earlier, leases are just one form of contract, and there's many of them out there. Some of the parties, some of the terms that you're going to hear thrown around a lot when you're dealing with leases, lessor is your landlord, lessee is the tenant. Third parties are often become involved in these. And what I mean by third parties, if you've got a hunting lease and you've got land you're leasing to someone else to hunt, and they bring their kid along, that kid would be a third party. It'd be the guest. So you need to be aware that often there will be third parties being involved in some of these contracts, whether they're mentioned in the lease itself to begin with. There's different types of leases out there. These are just a very rudimentary breakdown of some of the bare basic types of leases. Tenancy at will, periodic tenancies, tenancies for a term of years, and then the final one's tenancy at sufferance. No matter what type of lease you have, it's going to fall under one of these categories. Tenancy at will, this is a type of lease that's not that popular with courts. Basically what this is, we've got a lease and this lease will last so long as both of us agree to keep it going. When one of us decides they want to end it, they can end it. But what's a problem that might pop up under this? Say we do a year-to-year oral deer hunting lease. Lease starts January 1st, it ends December 31st. Both of us think this is a great idea. I'm the landowner, you're the hunter. January 1st, you come, you take possession of the land. Everything's going great. Goes into the spring, you go out there, you establish food plots, you've gone out there, you've set up stands, you've got game cameras up, you know where all the deer are going. You are gearing up for bow season to start. Then on September 1st, I decide, you know what? Your neighbors decided to offer me a substantially higher hunting fee. I think I'm just going to cancel this lease right now. Thanks for all the work you've done to this property, but I think I'm just going to lease it out to him. Here's your final 3 months of the payments you made. Are you going to be very happy about that? Absolutely not. You've put in all the work, you spent 3/4 of the money, and you got nothing out of the lease. Completely unfair. That's one of the problems that pop up with these tenancies at will. They can be used unfairly against one or both parties. Periodic tenancy. Most leases, at least in the state of Arkansas, are going to fall under this. These leases typically last longer or will be less than 1 year in length, and practically all of your oral types of farm leases fall under this. This is your basic month-to-month lease or year-to-year agricultural lease. The lease itself renews itself at the end of the term. So if you have an oral farm lease, some of these leases have gone on for years and years and years. The lease itself doesn't last for years. The lease only lasts 1 year in length, but when December 31st comes, January 1st, the lease just rolls over to a new term, and it's good for another year. And this happens over and over and over again until one or the other party takes steps to end it. The important thing about these is you've got to give adequate notice to terminate that lease. And what constitutes adequate notice is going to depend on how long the lease is in length and what state you're in. The third type of lease, and one that's the other really popular form of lease, is a tenancy for a term of years. These are the leases, especially if they are years in length, they will be in writing, and it will be for a set term. This is a hunting lease that will last from January 1st, 2012 to December 31st, 2015. It'll specify this is the set term or the length that this lease will run. Most recreational use leases are going to fall under this term of years. Anytime you have a written contract, they will almost always put in there, you know, this is the length of this lease. Because they do that, it falls under these term of years. The final type is the tenancy at sufferance. These don't arise very often and they don't last for very long. When these pop up is when, say you've got a term of years lease. It was a 3 years lease. It started January 1st, 2012. It's supposed to end December 31st, 2015. January 1st, 2016, the guy was supposed to be off, but he's still on the land. Now you've got to make a decision as a landowner. You've basically got two choices. One, you call the sheriff and have him evicted. Or two, you might decide to release the land to him. Until you make that decision which way you're going to go, he basically has this tenancy at sufferance. Once you make your decision, whether it's to evict him or to release the property to him, he's in that tenancy at sufferance period. As I said, it doesn't happen very often. When it does happen, it doesn't exist for very long. One of the questions we get all the time are oral leases even valid? And the answer to that is, of course they are, under certain circumstances. There's a thing called the statute of frauds, and every state has them. Here's the copy of the Arkansas statute of frauds. Basically what this is, the legislature has pointed out that there are some contracts out there that are so important in nature that you need to have them written down if they're going to be enforced. And usually this is a list of set things that they believe are extremely important, some of which are kind of antiquated. If you feel the need to betroth a child or grandchild, that type of contract has to be in writing. Other ones, if you're planning on selling land, all contracts for the sale of land must be in writing. For purposes of today, the two that really matter, if you're going to make an agreement to perform a service, that service must be able to be performed in less than a year. And if you are going to rent land, that land rent, that rental agreement has to be for less than 1 year of length. Otherwise, the lease must be in writing. So like I said, what does it mean? Oral leases and contracts, they are valid so long as they can be performed in less than 1 year. A couple of examples, that's all. I've always found this is the best way to work through them. You got a verbal agreement to lease land. The lease starts January 1st, it ends December 31st. Is this valid? The answer is absolutely. Practically every oral farm lease out there, this is exactly what they do. Start January 1st, they end December 31st. You have a verbal agreement for a hunting lease saying, hey, I want to rent your land for this upcoming deer season. Would that be a valid lease? Absolutely. How long does deer season last? Even if you string beginning of archery all the way to the final day of gun season, a couple of months. It can happen in less than a year. It's a valid lease. You have a verbal agreement for the next 3 hunting seasons. In this case, that lease would be no good. There's no way you can get 3 deer seasons in a year. So because of that, it'd be invalid, unless there's some other facts or admissions that don't pop in. There are a couple of exceptions. You're dealing with the law. There's almost always an exception to something. Here's a hypothetical on a services contract. You make a verbal agreement with a painter, and he's going to paint your house. Now, it should be able to be performed in 4 days, but because of a backlog of jobs, they don't have the right paint colors in stock, bad weather, the painter doesn't get around to painting your house, and it's been longer than a year since you've entered into the contract. Is that contract still valid? What do you think? The answer is, it is still valid. How long did I say it would take the guy to paint the house?
4 days.
4 days. The other stuff arose over the course of it, but that's not going to be a determinative factor. He could have painted it in 4 days, but he was held up for a variety of other reasons that was outside the contract. Because he could perform it in less than a year, contract's still valid, even if it's been longer than a year since he entered into it. But it's one of those things, you may have to go to an attorney to figure out if the contract's still valid. This is another one of those good reasons why it's always nice to have it in writing. Then there's no questions when it comes up later on. Now, like I said earlier, the purpose for the statute of frauds is there's some contracts out there, they're deemed so important that you should be required to have them in writing if you want to enforce them. There are some exceptions and ways to get around this in certain circumstances. It falls under the common law. Things like equitable remedies like partial performance or estoppel, a judge can find a way to make these contracts enforceable. And basically what we mean by these common law remedies is a judge makes a ruling on the grounds of fairness. You've done something or the other person has done something so that it shows that this lease was supposed to go longer for a year in length. Things like that would be making significant capital improvements. Say you're planting a multi-year crop. Say you have an agricultural lease, you made an oral lease with a guy, and you're going to rent this land for 5 years. You go in there and you establish an alfalfa crop on this land. Alfalfa is one of those crops, it's good for 5 years. It's extremely expensive to put in that first year, but you get to harvest it multiple years until the crop finally cycles out. It would be unfair if you go in there and plant that crop and invest all that money, get the first cutting, the first year's cutting, which typically isn't very good, and then that guy gets to go and cancel your lease and then harvest the next 4 years himself. So what a court might do is, well, no, we can see that you've made a significant capital improvement into this property, and that right there is evidence that the lease was supposed to go longer than a year. Other things is paying multiple years rent in advance. They're not going to assume that you just made a gift. There are other extreme examples that may apply, but the thing you got to realize is this is all about fairness. This would require a judge to agree with you and say, no, in this case, I think this evidence is enough to show that a contract should be enforced. There's nothing stopping the judge from finding the other way, though. So, I mean, it's a pretty risky thing. It's not something you want to rely upon if you're entering into a contract. This might be a stopgap if you mess up and things come out bad later on. That's all it is. Definitely not something to be relying on. What about terminating oral leases? I said that oral leases are valid. How do you get out of it? This is what you have to do in Arkansas. Every state's a little bit different. The general rule on termination of these oral leases, these periodic leases, is you have to give that term's length of notice. So say you have a month-to-month lease. You have to give at least a full month's notice to cancel that month-to-month lease. What about for the year-to-year lease, like is typical for agricultural land? In that case, Arkansas went in a couple of years back and stated that you can terminate these oral leases, but you have to do a couple of things. If you have a year-to-year farm lease and it's an oral lease, you have to send a written notice by certified mail to the renter on or before June 30th that the lease is no longer going to be renewed. So what does this mean? If you send them a letter with notice and it's not certified, that notice isn't going to be valid. If you send them notice on July 1st, you're going to be too late, and the lease is going to run for a whole nother year if the renter wants to keep it going. You have to follow exactly what they want for the termination of these leases. Other states that still go by the common law, they're just going to say, well, you're supposed to give 6 months notice. If you get out your calendar and you start figuring, if you have a lease that starts January 1st and ends December 31st, June 30th, that's the 6 month. That's the 6 month date. They just went in and put it in statute. There's nothing specific, though, when you're dealing with recreational leases. We can make a good guess, though, and it's probably going to fall somewhere under the farmland. I mean, this is the land that's going to be leased out. It's going to be farmland or forest land. That's the type of lease that in the termination policy they're probably going to follow. There's other things that need to be considered, though, besides money when you're drafting some of these recreational use leases. Who's going to be maintaining the property? Who's going to be using the property? How does the contract end? What happens if one or more of the people involved die before the end of the lease? How many people is going to be using the lease? Is it going to be a hunt club? Is there only going to be one hunter? Can they bring guests? How's that going to be handled? Who's going to be liable if anybody gets injured on the property? Who's the one that's going to be carrying the insurance policy? What terms is that insurance policy going to say? Do they have the right to assign or sublease that land to somebody else? Can your tenant turn around and lease the property out to somebody else if they get tired of using the lease, or if someone's going to offer them more money for it? What I'm going to do, kind of work through these, and if you'll notice behind the presentation in the book, I've got two different hunting leases. One is just a general hunting lease, and one of them is a lease form from the state of Mississippi. And I'm going to try to refer back through these as we're going through these and see how some of these are addressed. If you use an oral lease, are they valid? Yes, they're valid. Are you going to be addressing questions like we just talked about in an oral lease? And the answer is no. You're not going to be thinking about this stuff. And even if you do talk about it when you enter into the oral lease, if something happens 1, 2, 3 years down the road, how are you going to be proving that you guys talked about this when you entered into the lease in the first place? It's going to be the old he said, she said argument in front of a judge, and whichever one he finds to be more credible is the one that's going to win. First one up is maintenance of fixed assets. Most rental property out there, they're going to have some kind of fixed asset on it. Whether it's an old barn, it's a cabin, it's logging roads, it's something. They are going to have some type of fixed asset. The question is, whose responsibility is it maintained in? If you look at the first one, the Mississippi lease, on the third page, there's actually a structure, on section M, it says structures. All it talks about is, well, leasee's job is, they're supposed to remove everything they build on the property by the end of the lease. There's nothing on there that actually says, do you have to take care of the stuff that's already there? Some leases will deal with it, some leases won't. If you have a property and it's bare property, completely undeveloped, you don't need anything dealing with structures. One of the problems when you're looking at leases like this and when you're wanting to take form leases is, leases need to be tailored to fit your property. Going out and pulling a form lease off of the internet, you can get yourself into trouble. One of the reasons, and this is one of the reasons right here. If you went out and used this lease right here off there, all it says is, well, if the tenant builds something, he's got to take it down by the time he leaves. It doesn't deal with anything as in, what if the tenant tears something up of yours while he's on the property? In this case, whoever wrote this lease for this situation, this might have been a perfect lease because they might not have had anything on it and he didn't want anything on the property when the tenant left. If that was the case, this lease would work perfectly for that. But say you use this lease right here and it doesn't say anything about it, or say you use an oral lease. Say there's a house on the property. What are some of the issues that might pop up under this? Well, who takes care of the house? Well, who has the right to use the house? Does that tenant have the right to use that house as a hunting property, or were you planning on leasing that out to somebody else? If you did lease that house on the hunting property out to the tenant, does that tenant have the right to turn around and lease that house to somebody else? The general rule is, if you lease something to somebody, they can turn around and lease it to somebody else, unless you say otherwise. That could get into a pretty bad situation. You might know the person that you're leasing the land to for hunting, but you may not know the person that the tenant is leasing the house out to. You don't know if they're going to take care of it. You don't know if they're paying the tenant rent. There's a lot of things you may not be able to find out. There's also a lot of other things on the property. Barns, sheds, fences. Who has the right or who has the responsibility of maintaining this stuff? The general rule is it depends on what kind of repairs need to be made. Small repairs are generally the responsibility of the tenant. If you've got a hunting cabin on this place and it's being rented out to, and the light bulbs burn out, it's generally the tenant's job to replace it. Major repairs, though, are the duty of the landlord. One example is, say you got a problem with some shingles. If 1 or 2 shingles is off, it's going to be the tenant's job to replace those 1 or 2 shingles. If the roof blows off, it's going to be the landlord's job to replace the roof. Now, how many shingles have to blow off before the responsibility moves from the tenant back to the landlord? 10 shingles, 15 shingles, 25 shingles? Who knows? Doesn't say. You can put that kind of stuff, though, in the contract. If you have a written contract, you can specify who's going to be making these payments. If the repairs are over a certain amount, the landlord will take care of these repairs. There are often times where you might not want a tenant making these repairs. Say you've got a logging road that's going through your property, and the tenant tears up the logging road by going down through it when it's wet and muddy. By putting something in the contract saying, hey, it's tenant's responsibility for fixing the roads if he tears it up, you may not be looking at the full picture. Well, for one, where does that tenant live in relation to the land that you're leasing him for hunting purposes? If the tenant lives 100 miles away, how is he going to get his tractor and box blade all the way over to the lease to repair that road? The second issue is, do you necessarily want that tenant out there doing repairs to your road? You don't know how responsible they are. You don't know how skilled they are repairing roads. So these are things you need to think about on the front end. Maybe you want to do the repairs, but you may want to put some clause in there saying, hey, if you tear it up, you got to pay me to fix it. Do you restrict the uses of the property? If I enter into a lease with you and I say, hey, you want to lease me your property for the next year for $5 an acre? And you say, oh, sure. You might have been thinking that I was leasing it for hunting purposes. But there was nothing said in there about hunting purposes. I just said, hey, you want to lease the land? In that case, I can pretty much do what I want with that land for the next year. There may be certain things that you don't want occurring on that land that you're leasing out. What if that person's running an agritourism operation off that land? There are legal risks associated with if someone gets hurt on that land. They might be exposing you to a lot of risk if they're trying to run an agritourism operation or a hunting operation off the land they leased off of you. And what about some of the other things? Beekeeping, ranching, what they're doing, row crops. What if this person decides they're going to try to harvest some timber off there? Generally, that's something you can stop, but I mean, it's nice to have this in a contract, though, where you can say, you know, hey, these are the leases, these are the reasons why you can lease this property, this is what you can do on it, everything else is restricted. If you take a look at that first lease from Mississippi, it tells you what your rights are. Right there on the first page in section 3. The rights herein granted are restricted solely to hunting and shooting the following species: deer, turkey, squirrel, rabbit, ducks, possum, raccoon, bobcats, and nuisance species. You can also fish and camp. Nothing about harvesting of timber, no other types of agricultural pursuits. This is a hunting and fishing lease and camping lease only. What about the rights of the landlord? Chances are, if you've got land that you're leasing out and it's forested property, you're also going to want to have something in there where you can manage the timber. If your timber management plan calls for a little bit of selective cutting this year, is the tenant going to be very happy about you going in and harvesting timber when he's got the property leased out for hunting? Chances are they're not going to be very happy, especially if you're trying to do it during deer season. If you've just got an oral lease, you may have to fight this out with the tenant. With a written lease, on this first lease here, forest management, section P, forest and land management activities will take precedence over hunting activities. They went in and spelled out, you know, you do have this for hunting, but guess what? My forestry management practices are going to take precedence. If I need to get in there and take care of things, this lease gives me the right to do it. So will the property be used for hunting? Forestry practices, will it disturb the local wildlife? Maybe, depends on when you're doing it and how they're doing it. There's a whole lot of factors that apply into that. If you and the tenant want to go into a back and forth on, you know, these are when the forest management practices can occur, you're free to do that in the written contract. Does the tenant have the right to sublease out the hunting rights? Chances are they probably do. Do you want to divide up the species on there? This one right here, it listed all of the first lease, it listed all these different species on there as being something that the tenant can hunt. Is there anything stopping you though from leasing out property to multiple people? The answer is absolutely not. You might have a whitetail hunter that's only going to come in from Nashville, Tennessee during rifle season. If that's the case, you've got about a 2-week window in there where this guy's going to be out there hunting. What about the other 50 weeks of the year? You can set up these contracts where this 2 weeks of the year is designated to this hunter right here, and he's going to be hunting whitetail. But I've now got another guy a couple miles over